Okay, good morning everyone and welcome to another Wednesday morning seminar. Today we are joined by Ryland Ash, Managing Partner of Silver Shemmings Ash, and he's going to be discussing payment disputes in construction, a continuing problem, also known as I want my money getting paid. As always, Ryland is available if you have any specific issues on rylandash@silverllp.com. Always happy to answer any questions. If you have any questions during the session, please use the Q&A facility in the toolbar at the bottom, and Ryland will get to those when he's finished his presentation. So without any further ado, Ryland, it's over to you.
Julie, thank you very much for the introduction, and good morning and welcome everybody. Nothing quite like a good payment dispute seminar in the morning, I always say. So thank you for joining me. Today's discussion is a broad subject, as you can imagine. I've got some slides here so you can follow me through those. My background is initially as a barrister. I then qualified as a solicitor. I've worked on bigger projects, much smaller projects, and my work now is primarily relating to disputes in respect of payment. That makes up, I think, a large proportion of all the disputes that happen in construction. Invariably, it's about money. Either somebody wants to be paid or somebody doesn't want to pay, and that's broadly all the claims that we deal with. There's a small minority of cases where there are declarations sought about principle, and then issues obviously to do with damage and repair, and then valuations. But one thing's for sure is that this is a quick changing area of law, and you really have to keep your eye on the judgments that come out, or have somebody to do that for you, to keep a full grasp on where the law stands in terms of payments. Obviously, in respect of construction, things have changed dramatically over the years. If you go back to the original principles of construction and payment, back to the 19th century, there are cases there that would say that a builder only gets paid when they've completed all of the works. And that's a principle that, believe it or not, still stands today as good law. However, there have been changes in the law which has developed that principle. For example, the Construction Act, the Housing Grants Construction Regeneration Act, and the Local Democracy Economic Development Construction Act, which amended it. Those two pieces of legislation changed payment drastically in construction, because what they did was they gave contractors and subcontractors a right, the payee a right to interim payments, only if your contract is caught by that particular piece of legislation. And there are some exceptions there, such as residential occupiers who have to make their own arrangements. So in respect of construction now, the principles are that you're entitled to be paid on an interim basis. The question, of course, is, well, what is that interim basis? Is it monthly? Is it by way of stage payments? And then there are interesting issues about when things fall due, when you get paid, when notices should be issued, and how much you get paid, of course. And there are really sort of two broad categories of disputes. You have the disputes about the mechanism for payment, which comes about normally because either the contract is not particularly clear or the parties haven't followed it, which is the most common example of where things go wrong. And the second category is about how much you're entitled to be paid. And that, again, is very much a question of what the contract says in terms of the process for payment, the mechanism for payment, and the way that the contract is structured. I'm going to deal with those separately. I'm going to deal with the mechanism and what happens when things go wrong and how they go wrong, and what judges are saying these days about that type of dispute. and I'll also deal with entitlement in principle. But we'll start in my slides with your entitlement to be paid initially. So the first point is that you've either got a contract or not. And it is quite common, believe it or not, to have construction works being undertaken where there's no contract. And in those cases, there is a common law right to be paid. And that's point 2 here in my slide, where you have a principle in law that says that a party cannot be unjustly enriched. So if you undertake some work for somebody, you don't finalize the contract details, but nonetheless you do that work. If they've had a benefit from that, and that you've suffered a detriment effectively by doing the work, or some other detriment by supplying materials, for example, or incurring costs, then that party can't unjustly benefit or become unjustly enriched as a result of that. And so the law will give you a remedy. It will say, okay, you can be paid. As to what you get paid, the answer is not necessarily what you've incurred. The answer is that you get paid a quantum meruit, which is a Latin phrase, which means that you get paid a reasonable sum of money. So if you haven't got a contract, you get paid a reasonable sum of money for that work. And interestingly, I always say that if you ask contractors who are in contract whether they're being paid a reasonable sum of money, by the end of a job, they'll often say no. The intention is always that from the outset, you agree a reasonable contract sum, but it may be that you've underestimated things, or it may be that there are certain changes that have happened for which you have to take responsibility or liability, and therefore makes what looked like a good bargain into a bad one. But it's difficult to predict all of those issues from the outset, but you certainly have to try. So that's if you don't have a contract. Now, in most cases, I hope that you deal with that you have got contracts and that you actually read them, or you've got someone to read them. And so in respect of contracts that you enter into for construction work, the key question will be, what does the contract say about when and how you get paid? If a contract just has a lump sum in it, but it's nonetheless caught by the Construction Act, then there will be an argument to say that the Construction Act is implied into that contract and that you have a right to interim payments. And if you don't have any interim payment provisions in your contract, then they will be implied from the scheme for construction contracts, which is effectively a standard fallback position, which is implied into the contract, which gives you that mechanism for payment if you haven't agreed it. Obviously, if you have agreed it, then you have to stick to it. And if you look at the standard forms of contract, such as the JCT form of contracts, they will have provisions for interim payments. Now, the JCT contract broadly deal with interim payments in 2 different ways. Either you've got regular interim payments, so you measure the value of the works as at the dates that come and go, or you have stage payments. And stage payments are generally specified in a schedule, and the schedule will say when you've completed this aspect of the works or these activities, you get paid X, and then so on and so forth with the other stages of the work. One of the challenges with that is often it doesn't deal with variations, and the question arises how and when you get paid for those. And the answer to that is it will depend on what you've agreed, what else is in the contract. But under the JCT, the argument would be that they fall due within the month that those variations are instructed. But quite often I'll see bespoke forms of contract that don't deal with all of those details. And this is where disputes come in. It needs to be very clear from the outset that how the works are valued, what scope of works that value relates to, and how variations and changes are to be dealt with. And they are the key points, really. There are obviously issues in addition to that in relation to delay, which we won't cover in detail today because it's another topic for another day. But claims for prolongation, loss and expense and so on are also entitlements to payments where the contract should specify when that happens. The new JCT 2016 contracts all include provisions to say that applications can be made at the time, almost on an ad hoc basis, and they should be assessed within no later than 28 days from every submission, and therefore you've got a very clear mechanism. But that it's important to note that mechanism is effectively running alongside the existing interim payment mechanism and in addition to it. So you've got to work out from the outset what your payment cycles are and be very clear on the dates. Now, on that point, I think it's worth stressing that the amount of times I've lost count, the amount of times that parties effectively do not understand the difference between a due date and a final date for payment. And to me, that's a very important distinction, not least because it's within the Construction Act, and the Construction Act requires that distinction to be clear. So people talk about payment and payment dates, but actually, from a legal perspective under English law, what you've got to establish is the due date and the final date. The due date is the date up to which you will value the works. And that means that at that date, there is an entitlement in principle or not to payment or to measurement of the value of those works. That's the due date. It's a date of principle, really, not the date that you get paid. The date that you get paid or should receive funds or make payment in cleared funds by is the final date for payment. And the way that the law says it should work is that you'd have a due date, at which point you value the works, and then you have a number of days from that going forwards within which to make payment. And you have to make payment before the final date for payment or on it. And that's the distinction. And it's very important to understand that and to make sure that that's clear in your agreements from the outset, if possible. Now, the first point on my slides is to do with applications for payment there. So if you have a contract, sums will fall due when an application is made if the contract says so. So if your contract clearly says sums will only be due if you issue an application within a certain format by a certain date, then you will only have an entitlement to be paid if that happens. Now, there is a distinction again here between different forms of contract. If you look at the JCT contracts generally, again, all of them except design and build, and I'll come back to that, state that if you've got regular payments, then the due dates fall whether or not there's an application for payment. So you're going to have an entitlement to be paid on particular dates, whether there's an application for payment or not, which means there's a duty on the contract administrator or employer to value the works and pay something on those dates. So there's an automatic due date under the JCT forms of contract, save for the design and build. The design and build JCT contract is set up in a way whereby payment is driven by applications. So if you don't issue an application for payment under the design and build, there is no due date. So it's within the control of the contractor as to whether or not they make those applications and as to when they get paid. There's a date by which they ought to issue it. And so if they issue it before that date, up to 5 days before, then that's the due date. But if they issue it after, then the due date will wait effectively until it's been issued, which means, of course, you have these moving interim application and payment dates, which is a pain to keep track of, particularly if you're responding and you need to issue certificates, payment notices and or payless notices. So it's really crucial that you recognize that certain contracts will have moving due dates and certain contracts will have fixed due dates. You have to establish that from the outset. My third point there is that, as I said earlier, if you've got a construction contract and you haven't agreed interim payments, then there will be a statutory implication from the Construction Act, and that will kick in if your works are for more than 45 days or estimated to be more than 45 days and doesn't fall into one of the exclusion categories, such as residential occupiers. So that's most construction commercial contracts will fall into that category. And that means that if you just agree a price and a scope with somebody, automatically you've got to follow the scheme in terms of payment, which will mean you've got a due date every relevant period is every 28 days from commencement of the works, and you'll need to issue applications, payment notices and or payless notices, and make payments on a regular basis. And if you don't, you could be caught out by way of a smash and grab adjudication, for example, which we'll come on to later. So on this slide, I've just set down the basic elements of a payment mechanism under the Construction Act. And say for a due, it then says that a payment notice must be issued no later than 5 days after the due date. A payless notice must be issued before the final date for payment, but that period before can change. So you can agree that that can be up to the same day as the final date for payment, but normally it's 5 days before under the JCT contract. Contracts are amended to say all sorts of things. Under the scheme, it's 7 days before the final date for payment. And then the final date for payment, as I say, is the date by which payment should be made. So I think it's important to look at how the courts have treated these principles over the last few years. And in recent years, we've had a number of great cases on this. Mere Construction and Capital Residential Limited is a good example, going back to 2017. So what the courts decided is that you must set out the sum considered to be due and the basis on which that sum has been calculated. The notice in that case, it was a payless notice, fell short of the requirements that are required under the Construction Act. And as a result, it was considered to be invalid, which meant that the payer had to pay the full amount that had been applied for. Payless notice must at least set out the grounds for withholding, the sum applied to each of the grounds, with at least an indication of how each of these sums were arrived at. So that's good guidance for anybody pulling together a payless notice. You must set down, obviously, a calculation of how you've got to your figure. And if you're making deductions and you've got sums against them, make sure you break down those sums against each item of principal. And then with in respect of the principal, there must be some explanation. There is some flexibility over the way that you set that up. So, for example, you don't necessarily have to put all the detail in the notice itself. You could refer to other documents which maybe set out the position or letters between the parties, as long as it's clear from reading the payless notice the basis of the calculation, and that you can get to the answer to that question by reference to documents that have been provided, then you should be okay. But if you can't, this case reminds us that the payless notice is likely to be invalid. Does the other party understand what is being applied for? And this is one of the key questions, which is interesting often when you sit the other side of the fence or you're advising legally on these issues. You'd be surprised the number of situations where the parties say we're in dispute over payment, but actually the problem is not so much the principle, it's the explanation of that principle not being clear enough to the other party. So really, it's a case of setting things out in a very simple, logical and clear way to try and avoid disputes. And if you can do that with reference to contractual requirements, contract provisions that give you an entitlement, then you've got a much better chance of avoiding disputes or coming to a settlement. If things are not set out in a clear way and the other party can't understand them, then unfortunately disputes will arise and you'd end up needing a third party, not so much to make a decision, but to actually understand what the parties' positions are. The best way to do that, if you can't already, is to get advice, legal advice from someone like me early on, behind the scenes. Not a great deal of time needs to be spent, but just a couple of hours here and there to sit down, understand the provisions of the contract, understand the basis of claims or defending claims, and if you get that advice in the background, that will put you in good stead going forward. And what you really want to avoid, especially under JCT contracts, is the differences between the parties growing too much. You've got to try and understand the principles and try and agree your position or understand your position clearly as you move along. The biggest downside to a JCT contract is often that the parties start by agreeing mostly everything, and slowly the gap between them grows and grows and grows until you get to a final account position where it becomes very difficult to come to a sort of settled commercial position without really getting some form of understanding from a third party as to what the position is in relation to principle on many of the items. Whereas the better way to do that is to deal with those things earlier in the project and as and when they happen. So if the dispute is as to entitlement, have you set out adequately the reasons monies are due? So this is a distinction between entitlement and quantum, or principle and quantum. And so if you're first of all looking at principle and liability, that's what we tend to do in the law. We separate the two, because obviously if you decide that something fails as a matter of principle, and there's no point in looking at the quantum, it'd be a waste of time and money. So you start with the principles of claims for money, and you look at whether or not there's actually an entitlement at all. And sometimes it's a good strategy to actually say to another party, if you've got a dispute, look, let's forget about the quantum of this. Let's just deal with the principles and see where we get to, see if you can come to an agreement or not, but just to basically understand each other's positions better without looking at money at all. Obviously, money follows and can be a discussion if there's an establishment of entitlement. And so that split is often very useful from a tactical point of view. And obviously, it can save a lot of costs that might be unnecessary. If you throw a load of money at proving a loss, but it doesn't overcome the principal hurdle, then you've wasted good money after bad. So yeah, this split is very important when it comes to understanding your entitlement. And obviously when it comes to liability or a right, an entitlement, you need to go back to the contract and look at how the contract deals with payment, how it deals with the scope, and what the issues are in terms of this payment application, and whether there is a right under the contract for it. The best claims on this basis that generally tend to be ones based upon clear contract provisions that say, in the event that this happens, there is an entitlement. It becomes more difficult when there are claims to say, well, I thought this would happen. Now this has happened, and I've spent extra money and I want that back. Those types of general, very broad brush type claims tend to be the ones that fail. So specificity is important and particulars are important, but the grounds are the most important, really. Grounds and entitlement. The next category is quantum. Obviously, the value or cost are the two different things that we look at. So there's a very, very important distinction there when you're looking at the value of an item versus the cost of it. The value of something is where you use the contract as a reference point to determine what the value is of that item. For example, let's say under the JCT contracts for variations and changes, there are valuation rules which say that you'll use the contract rates plus a markup if the nature of work is the same or if the circumstances are the same for the work. It's only when they go outside of what the contract envisaged under the JCT that you then go into the fair and reasonable valuation, at which point you look at market rates and you might look at the cost, but it's still a question of value there because it's about value in relation to the original contract sum. Cost is very different. That it is what it is. It costs what it costs, and so you have to prove cost, whereas with value it's a measure, and so with cost there's a bigger evidential burden to demonstrate what's been incurred, and you will also have to demonstrate that cost has been reasonably incurred. So you probably have to show in relation to market rates that that you've paid a reasonable cost for something, but if you can do that, then the idea is you get reimbursed for that cost. The NEC contracts are a good example of cost-based recovery, where you're entitled to be paid the defined cost for compensation events, and so there's a clear focus on what cost you've incurred and what you can prove you've incurred. Whereas under the JCT, as I've said, you look at the value of those works under the contract. So that distinction is incredibly important, is often missed when parties are looking at what they're entitled to under a contract. The next subject here is variations and changes. And this is often also misunderstood. The starting point for variations is that you have to look at the contract, and you have to have a provision in the contract that allows for variations to exist. And you won't always have that type of provision. But most good contracts, standard forms of contract, do have these provisions. Unfortunately, there's inconsistency in the way that they're described, but nonetheless, you should be able to work out what they are. So the JCT contract flips from variation, the word variation, to change with a capital C under design and build contracts, for example. And the NEC contracts talk about compensation events. So there's a variety of descriptions in contracts. But the key thing is, if you haven't got a provision in your contract that allows for a variation, then you can't claim for them under that contract. That's sometimes a difficult concept for people to get their head around, but effectively what would happen is, if you don't have any variation or change provisions in your contract, and a new piece of scope is effectively instructed or agreed, then that new scope would technically become a separate new contract. Now, if you've got a brand new contract for piece of variation works as you might think they are, then of course that has its own complications, because it means as a standalone contract, there are then questions of how much you get paid, when you get paid, when you have to complete those works, and obviously recovery under that separate contract. It can't necessarily be bundled in with issues that relate to a different contract or the underlying contract in that case. And the answer to all of those questions really is that the law does fill in the blanks. If you've got a separate contract for what you thought was a variation was actually a new separate contract, new contract in its own right, the law says that if you don't agree a value, then you get paid a reasonable sum of money. That's unjust enrichment, unjust benefit can help you there. As to when you complete that work, you've got the Supply of Goods and Services Act, which says that you must complete within a reasonable time under section 14. As under section 13, it will say that you have to complete it with reasonable care and skill. So you've got a standard of workmanship that's implied. And then as to when you get paid, well, you may agree that as part of the variation agreement or the contract, the new contract that you've created. And if you haven't agreed it, then remember you can get the implied terms from the Construction Act if it's going to take more than 45 days. Otherwise, you'll be entitled to be paid once the work is complete, again under the Construction Act. So there are mechanisms in place and principles in place to fill in the blanks if you don't agree everything. But it's a very messy situation where you're under a main contract and then suddenly you've got a new separate contract for variation works or intended variation works. Obviously, the better position is to have a very clear variation or change mechanism in the main contract, which allows for these new works or changes to the works to be dealt with properly. The third point there I make is to do with design development, because I'm often asked, especially under design and build contracts, at what point does design development become a variation or a change under the JCT contracts? And the answer to that is it depends what the employer's requirements say. If what you've produced initially complies with the employer's requirements already, and then somebody asks for more design to be done to that, or a development of that particular design aspect, then in my view, it then becomes a change. It becomes a variation. To do any more design is above and beyond what you were obliged to do under the contract. But the JCT has mechanisms built in under the design submission procedure whereby you have to say these things at the time. If you just carry on revising and revising and revising designs because that's what a client asks you to do beyond the scope, and you don't say anything, then it becomes more difficult to argue that these are changes. And a client will say, well, you revised it because you recognized that the design wasn't ready or complete, compliant with the employer's requirements. But the straight answer is, as long as the design complies with the employer's requirements, there's no obligation after that to continue developing it. And if you're asked to do that, then you should be saying, well, I'll do it, but bear in mind that would be a change, and then you can seek to recover the additional design work as a change or variation under the contract. So how do variations arise? So the two main ways: first of all, events external to the contract cause a change in the circumstances, which gives rise to a change in the works. And the second one is obviously changes in the design scope or circumstances which are intentionally instructed. And they're the two broad categories for variations. There may be variations where you need to do more work or change the method of construction. But you need to bear in mind that they won't be a variation if what you're doing is completing the works that were originally envisaged under the contract. And if you've underestimated those works and given a lump sum price, then the risk will lie with the contractor or subcontractor in those circumstances. But if, for example, you may have underestimated, but you have a contract that allows for remeasurement of the works that you do, then in that situation, you would be entitled to recover the additional work. So it not only depends upon the mechanism, but also on the original structure of payment, whether it's to do with a cost reimbursable contract or a lump sum contract. If you're at the lump sum end of contracting, then the risk of having to do extra work to complete is yours. If it's a remeasurable or reimbursable contract, then the risk is very much with the employer or the main contractor. Variations happen in construction all the time, and obviously it's also a question of evidence. There are a few things that you should note when dealing with variations. First of all, a question: when a contractor makes a claim for payment for extra work, the primary question to be asked is whether the work is included within the contract, or does it in fact amount to a variation, as I was saying. In order to prove this claim, a contractor must show, first of all, the work was extra over that actually agreed at the contract. As I was saying, it needs to be clearly outside of the contract scope. Secondly, there was an express or implied promise by the employer to pay for it. So notwithstanding that it may have been in the original scope, you may get agreement from an employer or a main contractor to say, actually, I will pay you for this. And it doesn't matter what the contract says, if you agree that, then that will take priority over the contract, as long as you've got that clearly recorded in writing or recorded somehow. Or thirdly, an agent of an employer or main contractor had authority to give that instruction, and that instruction was valid. Often there are cases where instructions are not given, but work is done, and then a contractor struggles to recover sums of money in respect of that intended instruction. So being clear, one, who is authorized to give such instructions is an important thing to agree from the outset of your contract and project. And secondly, when those instructions are given, to test them at the time and make sure that they are being given validly and that they should be followed. And if they're not, or there's any question, again, you must raise these things at the time. If somebody new on a project is giving you instructions, you need to clarify with the employer or the main contact directly, person of authority, to make sure that those instructions should be followed and that they are a true agent of that party. So questions of agency can become important, but when there ever is a question of authority, what the law is looking for is whether or not someone has apparent or ostensible authority, and that essentially means that if you get the impression that somebody is sufficiently senior or has that authority because you've been told that they have the authority, and for example, let's say they've been giving instructions for a long time and you've been paid for some of them previously, for example, then the implication will be that they do have that authority, and then you would be deemed reasonable to treat that as a valid instruction. Standard forms of contract have express rules dealing with instructions and variations, of course. With the JCT, one must consider the recitals. The recitals are statements in a formal document that contain facts closely connected with the purpose of the contract. Second question is whether the variation goes to the root of the contract. The variation is to primarily deal with the unexpected rather than as a consequence of poor planning or frequent changes of mind. So the case of Walter, Lilly and Mackay was a good example of many things. It was a very interesting case. If you haven't read it, I suggest you read it for just for pure amusement, if nothing else. But what happened was Mr. Mackay was renovating and developing 4 houses in central London, very expensive properties. He originally had 4 contracts for them. Then he changed his mind and said, I only want 1 contract. So they put them all together. He then changed the scope several times, but he said it was design and build, so the contractor should just do what they're told. He refused to pay an extension of time and loss and expense. And no surprise, they ended up in court. And the court had a lot of sympathy for the contractor and said that essentially that they were entitled to an extension of time and loss and expense. And there's some good commentary on global claims within the judgment. But one of the comments was also that variations themselves shouldn't be dealing with poor planning or frequent changes of mind in terms of the way the works are done. So, you know, a variation will only be what the contract defines it as, is the point. It's not a get out of jail card to say, oh, well, I had to do extra work, it's cost me more, and therefore it's a variation. So it's very much dependent upon the exact wording of the contract and what the scope is when the contract was entered into. If we look at the JCT clause itself on variations, it talks about the alteration or modification of the design, quality or quantity of the works. Obviously, there's a design aspect in this particular contract, including the addition, omission or substitution of any work and the kind and standard of any materials or goods. So a very broad definition there. Alteration, modification, but also addition, omission, so taking things away, adding things, or substituting anything, and of the work and of the standard of materials or goods as well. Includes the imposition by an employer of changes to access, workspace, working hours, or the order of execution. So the point here is that if any changes are made to access or the working space or working hours or the order of execution instructed by or brought into place by instructions from or decisions made by the employer on behalf of the employer or main contractor, then the argument then is they are also variations. And it's important to be aware of those at the time, again, at the time they happen, to avoid any arguments later of accepting those or waiving any rights. So it's not only changes, clear changes to the works themselves, but also the circumstances surrounding the works and the environment in which the works are undertaken. In respect to the contractor's design portion, any instruction requiring a variation shall be an alteration or modification of the ERs. So this goes back to my point about design development, where there are employers' requirements and the design has reached that point, then it complies with the contract, and any change beyond that would be a change or variation under the contract. And if there's an instruction to modify the employer's requirements themselves, then again that would be a variation. So there's a distinction there between design changes, obviously, and non-design changes. But the non-design changes are broader under the JCT than they first appear, due to the fact you take into account the environment. There's also a contractor's reasonable right of objection under the JCT contract, which doesn't always exist under other forms of contract. And one of the sort of major injustices as contractors and some contractors sometimes see it, is the fact that if somebody instructs a valid variation under certain forms of contract, you have no choice but to get on with that work under the NEC, for example, and then fight about payment later, which is a difficult pill to swallow, particularly if you're not being paid properly for other works. And so this is an area where really, if you want to change this setup, if you want to protect yourself more when you're doing works from not having to effectively do any variation works if you're owed money, then you need amendments to the contract. You need to get legal advice, you need to change the contract or insist on certain provisions being added to your contract to protect you against that. But the JCT does have this reasonable right of objection in relation to instructions requiring a variation, but it's limited to things that will affect the efficacy of the design. So you can only really refuse to undertake changes where you can show that actually those changes are going to be dangerous effectively. You know, taking away posts from a steel structure because you don't like the look of them may be great in principle, but could be dangerous. So it's really, there's a caveat there, but of course there's nothing stopping you having a provision in a contract that I often draft contract amendments which will say that the contractor has the right to refuse to undertake variations or change work in circumstances where they believe that they're entitled to further payment, or you could have a blanket right to refuse to undertake variation works, which would be more difficult probably to negotiate, but may nonetheless be necessary. And it could be that, you know, a third party comes in if they want to change any of the works. So there are different ways to deal with this issue, but the JCT happens to deal with it in a way that limits what you can reasonably object to. So parties either agree the value of the amount is valued in accordance with the valuation rules if they can't. So under the JCT, you try to agree the value of a change or variation by reference to the contract rates or an uplift where appropriate. And if you can't agree, then one of the valuation rules will apply depending on which one it is that is relevant. And the valuation rules are quite simple. They start out with the contract rates with an uplift, market rates, and then finally day work rates, if you can agree them, that they will apply, and that the rates, if they're either agreed or in the contract already. Whether or not there is a disagreement over whether an item of work is a variation itself, most commonly it will be the value of the variation that will cause the issue. Usually the argument is on the price and effect of the program. The rules of valuation, if they apply, are mandatory. So the rules for valuation is not so controversial necessarily. Quite often it's to do with the effect of the variation on the program. Some contracts will, and the more basic JCT contracts, for example, minor works, and at the intermediate stage, they will say deal with loss and expense and extensions of time at the time that you deal with variations. Whereas when you get up to the standard building and design and build, you've got to separate out the effect of variations. You can agree the effect of a variation at the time the value or principles being agreed. And I think it's a good idea. As I said earlier, the more you can agree at the time things happen, the less you've got to argue about later, which then gives you a better chance of avoiding a final account dispute. So I think variations and changes should be looked at in the context of what the direct effect is and what the indirect effect is as well, and include the impact upon the program, if there is one. Extension of time, of course, should be claimed at that time through the proper notice provisions and then assessed. And then if there is a prolongation or loss and expense cost that relates to that variation, then you should try and get those agreed at the time. And if they're not agreed, then claims should be submitted, and you should go through the assessment process again at the time. Don't leave it until the end and try and roll it all up into one bigger claim, because then you've got less chance of settling. There is, in respect of non-payment, a very powerful right which comes from the Construction Act to suspend your works if you're not paid by the final date for payment. Now, before the new Construction Act, this right used to be linked to a failure to pay sums due by the final date for payment. The problem with that was that if you disputed what was due, then it could become unclear as to whether or not there had been a failure, and therefore relying upon the right to suspend was risky business, because if you suspended wrongfully and it turned out that you didn't have a right to suspend, then it could be said that you've repudiated the contract, which would lead to a termination, which was bad news. The new rules, or latest rules, say that if there's a failure to pay the notified sum, in that case, you can give a notice of intention to suspend. You have to give 7 days prior notice. And if you still haven't been paid, then you can suspend all or part of the works. If you're behind program, then this can be useful, because you can suspend parts of the work that perhaps most critical and would hurt the person who's not paying you the most, but then carry on with the rest of your works and possibly catch up in respect to that. So it can be very useful. You can also claim loss and expense if you haven't been paid and you're forced to suspend your works. So just the threat of suspension often works to get paid, and it's definitely worth looking at this right. If you think you haven't been paid all that you're entitled to, get me or someone to assess the contractual basis of your claim, whether or not you're entitled to those sums as a notified sum. And if you are, and you haven't been paid by the final date for payment, then you can issue a suspension notice, and that's a good kick up the backside if you haven't been paid. So that right is very, very powerful. When we're looking at what the courts have said about all of these issues, there's some very useful guidance. It really kicked off in 2014 with ISG Construction and Seavich College, where effectively the smash and grab adjudication was confirmed, and it started a wave of claims on that basis. What the judgment in that case said was that if you submit an application for payment and a payment notice is not, Payless notice is not issued or not issued in time in respect of that, then in that situation, you must pay everything that's been applied for. But moreover, Justice Edward Stewart also said that meant if you didn't respond to an application in time or at all, that you'd agreed the value of those works, which was a very powerful concept, because it meant that the value of the works had been set by default. Now, of course, if somebody had applied for payment and they'd added too many zeros to parts of their application, you'd be stuck with it. And that therein lied a quite a difficult hurdle to overcome for parties who were supposed to be paying people and knew that what they were applying for simply wasn't right. So we had a flurry of claims, and I was part of that wave of smash and grab adjudications and had much success in doing so. Then over time, what the courts started to do was to say, well, okay, if you want the benefit of this very draconian, effectively very black and white regime of getting paid everything that you've applied for, then you have to follow the rules properly. And so in Henia Investments, for example, and Beck Interiors in 2015, there was an application made which was relied upon as a default payment, and the claimant said, well, look, you haven't responded. This is ISG and CVIC. You need to pay me. There's no Payless notice. And the courts actually refused to recognize the payment application as valid. And the reason they said that, Justice Aikenhead said that the substance, form, and intent of the application needs to be clear. It needs to be very, very clear when you submit an application for payment, which period it relates to, which provisions of the contract you're relying upon, and how the calculation has been reached. And if those things aren't clear, then there's a chance that the courts will strike it out as an invalid application. It's exactly what they did in this case. In this case, the application itself actually had the incorrect due date stated on it, and there were arguments to say that it was clear enough and so on, but the court said no, it needs to be very clear which period this relates to, which due date it relates to, and what is the basis of calculation. We then had Jawabi Properties in 16, where again there was an interim application which was deemed invalid because it stated the wrong due date and related to a different period. And this is where the contract, effectively the parties had disregarded the contract process, but still, nonetheless, the court said, look, unless it's tolerably clear what period this relates to, it would be very harsh of us to then say, well, you get paid everything you've asked for. It needs to be clear to the person receiving it what that period is, how much you're claiming, and so they can make a reasonable assessment. And so they couldn't be penalized for not responding to something that they couldn't really clearly understand the effect of. So that was Jawabi. We then had the wonderful case of Grove Developments and S&T. And in this case, effectively what happened was the decision in the earlier decision about smash and grab adjudications was essentially overturned. Although it didn't specifically say that, it was quite clear when you read the full judgment that Lord Justice Coulson felt that the smash and grab culture had gone too far. And so what he decided here was that even where there is a smash and grab adjudication, because someone's simply not responded by way of Payless notice, you can nonetheless have a separate dispute over the true value of the works under that same application. But there's an important caveat to that, which is that you have to essentially pay now and argue later. So if there is a smash and grab and you've got no defense to it, unfortunately, you're going to have to pay the amount that has been applied for. This is the safest tactic, really, and then go straight in with a valuation dispute. Now, what you can do from a tactical point of view, and often I would advise parties to do, is that even before you make the payment, you can start a true valuation adjudication before payments obviously being made of a smash and grab application. And then if you get that decision first, before a smash and grab application comes in or dispute is referred, then you can trump that with a true value dispute decision. And then if somebody tries to then go to court with the smash and grab, you'd have a defense. And so effectively you would enforce the true value at the same time as the smash and grab, and it would cancel it out. So there are ways around things now, but what this has led to is less sort of technical smash and grab adjudications and a lot more adjudications that relate to the proper value of the works, which is really what adjudication should have been about. But it does mean that payment disputes becoming more prevalent, more technical, and I've seen a lot more expert evidence, quantity surveying input in the earlier stages of disputes developing now. And so that's worth considering as well, whether or not actually you need to get some expert advice at an earlier stage. And then finally, I wanted to make some reference in the context of getting paid to the coronavirus and the effect that that's had on things. There's an interesting case here from earlier this year, Millcrest Developments and Waters. Essentially, it was an adjudication commenced, and there was an application for an injunction to stop it, to say, look, this is the middle of lockdown. This is obviously after lockdown. Lockdown came into play. It would be a breach of natural justice for this adjudication to carry on because we can't get hold of papers and witnesses, and various other things such as a site visit would be difficult or impossible. The courts said, no, you're not getting an injunction. And in fact, you should have been carrying on with these proceedings. It's not an excuse. And that's effectively what happened. The adjudication continued and the decision was made. So there's some guidance there to say, look, even if we're in lockdown, if there's enough evidence, then the course of justice needs to run. And I myself have been involved in a number of online hearings throughout this difficult period. These decisions are still being made. We can't stop everything, including the course of justice. So it's important that these things continue, and the courts have confirmed very much that that's the case. The parties are just going to have to measure and work out how best to deal with these issues on a practical basis. A couple of examples of that were the court said that you could have a site visit where just the adjudicator, for example, or the judge visits the site on their own, has a look around for themselves, and can make a decision on that basis. And equally, there was an encouragement to have a list of issues drawn up for such an event by the referring party, which could help the adjudicator make a decision on those points without any other assistance. So lists of issues within adjudications is a good idea. And lockdown will be no excuse for not being able to deal with a dispute. So be prepared, be ready, and don't expect to have any sort of extra flexibility during these difficult times. So in conclusion, thank you again for listening. This subject is a very broad one. It's complicated. It covers a number of issues, but the key points are that you should look at your contract terms, make sure you're very clear on what the scope is, what the provisions say about variations, follow the processes for those things, keep records of what happens, obviously record if you don't agree on certain points, understand the principles, check the authority of people who are giving instructions if it's not clear from the outset, understanding payment notice provisions and the application and Payless notice process is very important, getting the content right, otherwise they're not likely to be held to be valid, and effectively keep calm and carry on with things as you would normally do. Thank you very much for listening. I'm going to turn over to Julie now, who can hopefully help me with any questions that may have come through whilst I've been talking.
Okay, we do have a question here, which is, what is the legal proceeding if the main contractor has been paid for the works, but the payment has not been then processed to the subcontractor?
Okay, well, there's help in the Construction Act itself for this one. So what the Construction Act says is, I believe it's section 113 says that you cannot have a pay when paid provision. So you can't have a provision in a contract that says that I will pay you once I get paid. So that could be relevant to this. But if they have been paid and there is no such provision in the contract, then the fact that they've been paid is not really relevant. The point is, are you entitled to be paid under your contract or subcontract or not? And that's really the key aspect to it. If you know that they have been paid, then that's even more reason to seek to enforce your rights. And I would recommend that you would, in the first instance, do that by way of an adjudication. And I would bring that as quickly as possible, because if they're not making payments, notwithstanding the fact they've received payment, to me, that is a bit of an alarm bell in terms of the state of the liquidity of the main contractor. So my advice in that situation is to go after your money as quickly as possible to hope that you get paid before anything bad happens to the contractor, they go under, or they pay somebody else instead of you.
Okay, another question here. Someone's saying that they have a payment schedule, the contract has been delayed and the schedule has expired. The client refuses to issue an updated schedule. Where do they stand?
There is a very interesting case on this involving Balfour Beatty, where it was held that if a payment schedule expires, there is no right to any further interim application or interim payment until the final statement. Right, so that's the legal position. Now, the issue in that case, however, in my view, or the difference in that case, was that that was under a contract with stage payments. And that was why the court decided that because you'd agreed stage payments and the stages had ended, that you don't get paid again until the end of the project. If your contract includes provision for regular monthly payments, even though there is a schedule of payments that may have expired, there may be an argument to say that the interim payments continue up to the final statement. So that would be one where I'd have to look at the contract terms, and I'd be happy to do that. And we could determine whether or not there was a right to further interim payments.
Okay. Another question here regarding valuing a variation. Does pro rata to a similar item or to our schedule of rates take precedent?
It depends what the contract says. Under the standard JCT contract, if the works are of the same nature, then you would use the contract rates. If they're in different conditions, then you would use the contract rates with an uplift. So pro rata of contract rates would only really be used under a JCT contract where the works are of the same nature and type and in the same conditions. Okay.
Right, that appears to be all of our questions for today. So thank you very much for your time, Ryland. Very much appreciated. Thank you everyone for attending, getting out and logging on at 8 o'clock on a Wednesday morning. And we will hopefully either see you again tonight at 6 for tonight's programming of time with NEC and JCT with Richard, or again very shortly. Thank you again, Ryland.
Thanks very much.
Everyone.
Thank you, everyone.
Bye.
Bye. Thanks, Jules.
No problem. Speak to you later.